Case 1. Carolyn Warmus. When Westchester County detectives reviewed the visitor logs and phone records surrounding the death of Betty Jean Solomon in January 1989, a recurring name surfaced across multiple communication threads, one that kept appearing in proximity to the victim's husband with a frequency that investigators noted as statistically irregular for a professional acquaintance. Carolyn Warmus was, by every external measure, someone who had arrived. Born in 1964 into a wealthy Michigan family, her father, Thomas Warmus, was an insurance executive who had built a considerable fortune. She had grown up in an environment of visible success and social expectation. She attended the University of Michigan before completing a master's degree in elementary education at Columbia University's Teachers College, credentials that positioned her at the top of her field before she had turned 25. In the fall of 1987, she took a teaching position at Greenville Elementary School in Scarsdale, New York, where colleagues described her as intelligent, composed, and professionally capable. To the parents of her students and the administration she worked under, Warmus presented a picture of structured ambition, a young woman with education, resources, and a future that appeared to have no obvious ceiling. What those same colleagues did not see, at least not at first, was the private trajectory that had begun to define her life outside the classroom. Sometime in 1987, Warmus began an affair with Paul Solomon, a married fellow teacher at the same school. Solomon's wife, Betty Jean Solomon, was 40 years old and living with her husband in Greenburgh, a community in Westchester County. The Solomons had a daughter together. By all documented accounts, Paul Solomon did not pursue the relationship with the same intensity Warmus did, a disparity that would become central to what investigators would later reconstruct. The events of January 15, 1989, began to take shape through a combination of physical evidence and witness testimony assembled over more than 3 years of investigation and 2 separate trials. That evening, Betty Jean Solomon was killed inside her Greenburgh home. She had been shot 9 times. Prosecutors alleged that Warmus traveled to the Solomon residence that night during a window of time that physical evidence would later be used to establish, carried out the attack, and then met Paul Solomon for drinks afterward at a local restaurant, an alibi encounter that witnesses confirmed, but that prosecutors argued was part of a calculated sequence. The firearm used in the killing became a central investigative thread. Records later indicated that Warmus had obtained a .25 caliber pistol through a private investigator named Vincent Parco, using a set of identification documents that were not her own. The investigation that followed was anything but linear. Paul Solomon was initially treated as a person of interest, a common investigative posture in domestic homicide cases, and detectives spent considerable time working through the timeline of his whereabouts. It was the phone records and independent witness accounts that began to redirect the inquiry. Investigators documented that Warmus had, in the period leading up to the killing, hired Vincent Parco to conduct surveillance on Paul Solomon and gather personal information, a detail that placed her professional conduct well outside any recognizable boundary. Parco's records became a significant investigative asset. Additionally, detectives established that Warmus had followed Paul Solomon uninvited on a trip to Puerto Rico, a behavioral pattern that witnesses in Solomon's personal circle were able to confirm. A receipt from a suburban Philadelphia gun shop, later matched to the acquisition of a silencer, was recovered as a separate piece of evidence. A black cashmere glove with microscopic bloodstains was found at the scene of the crime, physical evidence that prosecutors would work to connect to the weapon used in the killing. The combination of communication records, the paper trail tied to the firearm, and testimony from individuals who had observed her conduct around Solomon built an evidentiary architecture that the prosecution assembled over the course of 2 distinct trials. The first trial, which concluded in April 1991, ended in a hung jury. The panel split 8-4, unable to reach a unanimous verdict. Prosecutors immediately announced their intention to retry the case. The second trial began in early 1992 and featured several pieces of evidence not fully developed in the first proceeding, including expanded testimony related to the glove and the silencer receipt. Defense attorneys challenged the reliability of the forensic chain of custody and questioned the credibility of witnesses connected to Parco, arguing that the physical evidence had not been definitively linked to Warmus. The jury, In the second trial, deliberated and returned a verdict of guilty on 2 counts: second-degree murder and criminal possession of a weapon. The date was May 27, 1992. At sentencing, Carolyn Warmus received 25 years to life in state prison. She was housed within the New York State Department of Correction System, and over the years that followed, filed multiple appeals, challenging aspects of both the evidentiary record and the trial proceedings. None were successful in reversing the conviction. She became eligible for parole after serving the mandatory minimum and appeared before the board on multiple occasions. In June 2019, after serving 27 years, Warmus was granted parole and released. The terms of her release included parole supervision for the remainder of her natural life. The phone records that first drew investigative attention back in 1989, those repeated documented contacts between Warmus and a man whose wife would be killed, had anchored a case that took 3 years to reach a jury and 3 decades to reach its current resolution. What the Warmus case established, above almost anything else, was a documented pattern: obsession as prologue, surveillance as method, and elimination as endpoint. The next case in this documentary follows that same underlying logic, but it unfolds not over months of premeditation, not in a suburban home in Westchester, but on a single stretch of city street in the hours after midnight, captured in real time by cameras that no one checked until a woman was already gone. Case 2. Adrian Ernest Bayley. It was not a missing persons report that first focused investigative attention in Melbourne in September 2012. It was a piece of CCTV footage pulled from a camera mounted above a shopfront on Sydney Road, Brunswick, that showed 2 people walking in the same direction at the same time, at a distance that would become the subject of frame-by-frame analysis by detectives in the days that followed. Adrian Ernest Bayley was 41 years old in September 2012, and the record that followed his name through Victoria's criminal justice system was both extensive and, in the assessment of those who later reviewed it, formally, deeply inadequately managed. He had been convicted of rape on multiple occasions, prior convictions for raping 5 women across a span of years involving multiple victims, and had been released on parole in March 2010, despite documented risk assessments that flagged his danger to women. His parole conditions were monitored by Community Corrections Victoria, and his conduct on supervision had, by the accounts of investigators who reviewed the file after September 2012, involved violations that had not been escalated with the urgency the documented risk level warranted. Bayley had worked in the transport industry and was, in the daily texture of his community, an unremarkable presence, the kind of person whose documented history existed in files that the people around him had no access to, and whose behavior in ordinary social settings gave no obvious outward indication of what that file contained. Jill Meagher was 29 years old, Irish-born, and had built a professional life in Melbourne that reflected both her talent and her place in the city's media community. She worked as a producer for ABC Radio and had moved to Australia with her husband Tom Meagher, settling into the Brunswick neighborhood that had become her daily geography. On the night of Friday, September 21st, 2012, she attended a work function with colleagues at a bar on Sydney Road. The event wound down in the early hours of Saturday morning, and Meagher, who lived approximately 800 meters from the venue, began walking home along Sydney Road. Colleagues later confirmed they had offered to walk with her. She had declined, noting the short distance. The time was documented through a combination of witness accounts and digital records as being around 1:30 in the morning. The CCTV footage, recovered from multiple cameras along Sydney Road, captured a sequence of events that investigators spent the initial days of the investigation painstakingly assembling. Footage showed Meagher walking along the footpath. It also showed Bayley. The documented sequence, as prosecutors would later establish through frame analysis and witness corroboration, showed Bayley following behind Meagher, approaching her, and the two engaging in what witnesses in the area later described as a brief exchange on the footpath. After that point, Meagher did not appear on any subsequent camera footage. Her husband Tom filed a missing persons report the following morning after she failed to return home. By Saturday afternoon, friends, colleagues, and community members had begun organizing search efforts and distributing her photograph across social media platforms, an outreach campaign that spread with a speed and scale that drew national and international attention within 48 hours. The investigation proceeded on parallel tracks. Detectives from Victoria Police reviewed hundreds of hours of CCTV footage, pulling feeds from businesses, traffic cameras, and private installations across a wide radius. The footage of Bayley following Megger along Sydney Road became the critical visual document. It was not immediately apparent to investigators reviewing the initial footage whether the person behind Megger was connected to her disappearance, and cross-referencing that figure against known offenders on active parole supervision in the area required both database work and manual review that took several days to converge. On September 27, 2012, Bayley was arrested at his home address in Coburg. That same evening, he led investigators to a location near Gisborne South, approximately 50 kilometers north of Melbourne, where Meagher's remains were recovered from a shallow grave. Bayley appeared before the Victorian courts and entered guilty pleas to both rape and murder on April 5, 2013. Pleas that spared the Megger family a contested trial and allowed the sentencing phase to become the primary legal proceeding. On June 19, 2013, Justice Jeffrey Nettle sentenced Bayley to life imprisonment with a non-parole period of 35 years, explicitly noting his assessment of Bayley as someone who represented an ongoing and serious danger to the community. In the sentencing remarks, the court also addressed the documented failure of supervision, the fact that a man with Bayley's conviction history and assessed risk profile had been on parole at the time of the killing. A formal investigation into the conduct of Bayley's parole supervision was subsequently initiated, examining both the specific decisions made in his case and the broader systemic protocols governing the management of high-risk offenders on release. Bayley remained in custody at a Victorian correctional facility with the non-parole period, making any review of his release status unavailable until 2048 at the earliest. The CCTV footage from Sydney Road, the same footage that first flagged an anomaly in the frame-by-frame analysis detectives had initiated days into the investigation, became central evidence in the legal proceedings and was subsequently referenced in multiple public discussions about urban safety, surveillance infrastructure, and the management of paroled violent offenders in Australia. The Megger case was documented within a single night. Everything, the pursuit, the encounter, the burial, the community response, the arrest, collapsed into a compressed timeline measured in days. The case that follows operated on a different clock entirely. Months of documented surveillance, months of accumulated evidence of intent, and one afternoon in a parking garage that ended what those months had been quietly building toward. Case 3, Shannon Crawley, a maintenance worker at the Campus Crossings apartment complex in Durham, North Carolina, reported to responding officers on the morning of January 4th, 2007, that he had observed a woman running from the vicinity of the parking lot toward a burgundy SUV, seconds after hearing a single gunshot, a detail that investigators documented in the initial incident report, and that would become one of the load-bearing pieces of witness testimony in the case that followed. Shannon Crawley was 27 years old in early 2007, living in Durham, and by most outward indicators, a young woman whose life had not yet taken any shape that would distinguish her from her peers. She had no significant prior criminal record, no institutional history that placed her in contact with law enforcement, and no public profile that would have drawn notice. What she did have, and what investigators would reconstruct in careful detail through digital records, telephone logs, and the accounts of people who knew both her and the individuals at the center of the case, was a secret. For a period of time whose exact duration became a matter of evidentiary assembly during the subsequent investigation, Crawley had been involved in a relationship with Jameer Stroud, a Greensboro Police Department officer. That relationship was not publicly acknowledged. It existed in the documented record as something conducted deliberately outside the visibility of Stroud's professional and social world. By 2007, Stroud had become engaged to Danita Smith, a 25-year-old graduate student at North Carolina Central University, and the engagement was known within their shared social circle. The events of January 4th, 2007 were reconstructed through a combination of the maintenance worker's account, physical evidence recovered at the scene, and subsequent forensic and investigative work. Danita Smith was observed on security and witness accounts walking toward her vehicle in the parking lot of the Campus Crossings complex, where she resided during the morning hours. Evidence later indicated she had been approached from a position that placed the shooter behind her. She was struck by a single gunshot to the back of the head. She was transported to a hospital and pronounced dead. The maintenance worker's account of the burgundy SUV and the figure running toward it gave investigators their initial directional lead. The specificity of the attack, its location, its timing relative to Smith's known schedule, and its execution led detectives to assess from early in the investigation that the circumstances reflected prior knowledge of the victim's movements, rather than an opportunistic encounter. Investigators from the Durham Police Department, working in a case that required particular procedural care, given that one of the individuals connected to the victim was a sworn officer within the same department, began pulling phone records and conducting interviews within the first 48 hours. The records established a documented communication pattern between Crawley and Stroud in the period leading up to the killing. Cell tower data placed Crawley's phone in the geographic vicinity of the Campus Crossings complex during the window of time consistent with the attack, a finding that investigators added to the growing file alongside the maintenance worker's physical description. When investigators examined Crawley's vehicle, they were able to establish a connection between its description and the SUV documented in the witness account. Crawley was identified, questioned, and charged. Her response to investigators was to deny involvement and, critically, to suggest that Stroud himself had been responsible for Smith's death, a counter-narrative that prosecutors would later address directly at trial by presenting the communication records, location data, and physical evidence as a coherent account of what the documented facts established. Prosecutors charged Crawley with first-degree murder, arguing that the attack had been premeditated, that she had obtained a handgun, identified Smith's residence, established Smith's routine, and positioned herself to carry out a planned ambush. The defense maintained Crawley's denial and pressed on the reliability of the cell tower data and the maintenance worker's identification, arguing that the prosecution's case rested on circumstantial foundations that had not been corroborated by direct physical evidence, placing Crawley at the point of the shooting with the weapon. The jury heard testimony over the course of a trial that concluded in February 2010, more than 2 years after the killing, a timeline that reflected the complexity of the evidentiary assembly and the procedural care required by the case's institutional dimensions. On February 22, 2010, the jury returned a verdict of guilty on the charge of first-degree murder. Judge Ronald Stevens sentenced Crawley immediately following the verdict to life in prison without the possibility of parole, a sentence that carried no review mechanism, no parole eligibility, and no pathway to release. Crawley has remained incarcerated in the North Carolina correctional system since that sentencing. The maintenance worker, whose morning observation placed a running figure and a burgundy SUV in proximity to the sound of a gunshot, had, without any investigative training or forensic expertise, provided the thread that investigators pulled until the full evidentiary picture came into focus, where the Crawley case turned on a single witness in a parking lot and a phone record that placed someone where they claimed not to be. The case that follows documented its own warnings across an entirely different kind of paper trail, one assembled not in months, but across decades, and ignored at nearly every institutional checkpoint it passed through. Case 4. Albert Flick. A review of Maine Department of Corrections records conducted in the weeks following July 15, 2018, surfaced a 2010 civil protection order filed in Androscoggin County that named Albert Flick as the respondent and documented a pattern of unwanted contact directed at a woman at a Lewiston laundromat. Investigators noted the order had not functioned as a barrier to his subsequent access to the same type of location 8 years later. The file had existed, it had been read, it had not been enough. Albert Flick was 77 years old in the summer of 2018, and the institutional record attached to his name was neither short nor difficult to locate. He had grown up in Maine and spent the better part of 4 decades cycling through the state's correctional and probation systems, a documented history that those who reviewed it at multiple intervals had formally assessed, noted, and in critical instances set aside. To the residents of Lewiston's working-class neighborhoods, Flick was unremarkable, in the way that older men living alone in mid-sized post-industrial cities often are: present without being visible, familiar without being known. He had no public profile that distinguished him from the community around him. He held no institutional position that drew outside attention. He was, by every outward indicator, a man whose life had contracted to its most ordinary dimensions. The record behind that appearance told a different story entirely, one that stretched back nearly 4 decades and had passed through the hands of corrections officers, probation supervisors, court administrators, and judges across multiple jurisdictions without producing an outcome that altered the trajectory it described. Flick had been convicted in 1979 of stabbing his wife Sandra to death in Westbrook, Maine, an attack carried out in front of her daughter. He was sentenced to 30 years and served approximately 21 before his release in 2000. Prior to that release, correction staff formally documented their assessment that Flick continued to represent a danger to women, a conclusion drawn from his institutional conduct and his prior history, and entered into the official record with the specificity of a professional evaluation. That assessment was filed, reviewed, and did not alter the outcome of his release. In the years that followed his return to the community, Flick was arrested and incarcerated on multiple further occasions for conduct involving women: assault, criminal threatening, tampering with a witness, each time returning to Lewiston after completing his term. A 2010 civil protection order, obtained by a woman he had fixated on at a neighborhood laundromat, represented the most recent formal legal record of that pattern before the summer of 2018. A judge reviewing Flick's case that same year determined that, at his age, he was unlikely to remain a credible threat. He was released in 2016. He was 74 years old. Kimberly Dobby was 48 years old and a resident of Lewiston. She was the mother of twin boys, and the family made regular use of Roncourt's laundromat in the city. Witness accounts and facility records documented that Flick had been present at that location on multiple occasions in the weeks prior to July 15th, and that his conduct around Dobby had been noted by individuals in the facility. Those observations had not been formally reported to authorities before the events of that morning. On July 15th, 2018, Dobby was at Roncourt's laundromat with her sons present when Flick approached her and produced a knife. He stabbed her 11 times. Bystanders who were present attempted to intervene and summon help. Dobby died at the scene from her injuries. Surveillance footage recovered from the laundromat captured the sequence of events in their entirety, and Flick was taken into custody the same day after being subdued by bystanders at the scene. The investigation that followed required less reconstruction than assembly. Witnesses had observed the attack directly. Flick's identity was established immediately. Surveillance footage from the laundromat also documented Flick entering a store and purchasing 2 knives in the days preceding July 15th, a detail that investigators noted and that prosecutors would later present as evidence that the events of that morning had not been spontaneous. What investigators built in the weeks that followed was not a case about identification. It was a case about pattern. The full documented history was pulled and organized. The 1979 murder conviction, the multiple post-release arrests, the 2010 civil protection order, and the witness accounts placing Flick at Roncourt's laundromat on dates prior to the attack. Each layer added to a record that described not a single isolated act, but a continuation of conduct formally noted and formally predicted across nearly 4 decades of institutional contact. The question investigators found themselves returning to was not who had been responsible. That had been established within hours. It was how a file this complete had produced an outcome this predictable. The trial proceeded in Androscoggin County Superior Court. Prosecutors presented the surveillance footage documenting both the knife purchase and the attack itself, the eyewitness accounts from the laundromat, the forensic evidence establishing cause of death, and the full prior history as a coherent evidentiary narrative. Defense attorneys focused on Flick's age and cognitive state, presenting testimony from medical and psychological witnesses arguing that his capacity at the time of the attack warranted consideration by the jury. The jury heard the complete record and returned a verdict of guilty on the charge of murder on July 17, 2019, deliberating for less than 1 hour. At sentencing on August 9, 2019, Flick received a sentence of life in prison. Given his age at the time, 78 years old, the term carried no realistic prospect of release under any actuarial assessment. The 2010 protection order, surfaced from county records in the opening weeks of the investigation, had documented a warning the system had not converted into prevention. Following the conviction, Maine lawmakers and criminal justice advocates initiated a formal review of the protocols governing the release of violent offenders with documented risk assessments, examining specifically the gap between what an official evaluation concludes and what the system is structured to act on. The administrative record had existed for decades. It had simply never been the mechanism that stopped him. Where the Flick case turned on a documented history that institutions repeatedly failed to act on, the case that follows produced its own paper trail through an entirely different mechanism, one built not across decades of court filings and corrections evaluations, but across months of deliberate digital construction aimed precisely at the person it was designed to destroy. Case 5, Giselle Esteban. When Hayward, California, investigators reviewed the search history recovered from Giselle Esteban's electronic devices. In the weeks following Michelle's disappearance in May 2011, they found a documented sequence of queries, including searches for residential addresses, methods of forced entry, and means of inducing cardiac events, that had been conducted across a period of months prior to the date Leah was last seen. A digital record whose chronological structure indicated to investigators a pattern of accumulating intent rather than impulsive conduct. Giselle Esteban was 27 years old in the spring of 2011 and had grown up in the Bay Area communities, where much of the case would eventually unfold. She and Michelle Liu had attended the same high school, a biographical overlap that investigators would later identify as the origin point of a social connection that had not remained dormant, but had instead, in the years that followed graduation, been actively reactivated in Esteban's attention. Lee, also 26, had built a life that by any measure reflected sustained effort and forward momentum. She was enrolled in nursing school at Samuel Merritt University in Oakland and completing clinical rotations at Kaiser Permanente Medical Center in Hayward, a demanding academic and professional schedule that structured her weekly calendar with a predictability that would, investigators later established, have been observable to anyone who knew her institutional affiliation and took the time to map her routine. Esteban's own circumstances in 2011 included a relationship with a man named Scott Marasigan, whom she shared with Le as a mutual acquaintance from their overlapping social histories. The documented record established that Esteban had developed the unfounded belief that Le and Marasigan were involved romantically, a belief unsupported by any verified evidence, but one that, according to the reconstructed digital and communication record, had become the organizing fixation of her conduct across the months preceding May 2011. The sequence of events on May 27, 2011, was reconstructed through physical evidence, cellular records, and forensic analysis assembled over the 4 months between Lee's disappearance and the recovery of her remains. Leah was completing a clinical shift at Kaiser Permanente Medical Center in Hayward, when evidence later indicated she entered the facility's parking garage during a scheduled break. Investigators determined through surveillance footage review and access record analysis that she did not return from that break. Her car, a Honda CR-V, was later identified as having been moved from the medical center parking structure. Cellular data and forensic evidence placed Esteban at the medical center location during the window consistent with Lee's disappearance. Blood evidence recovered from Esteban's shoe and from the interior of Liz's CR-V was submitted for DNA analysis, and the results connected both samples to the case in ways that prosecutors would later present as directly linking Esteban to the vehicle and the location after the point at which Leigh was last documented alive. Lou's remains were discovered on September 17, 2011, in a remote area near the Pleasanton-Sunol border, a canyon location reached by a road that required deliberate navigation, not accidental proximity. The investigative work that followed Lou's disappearance was notable for both its scale and the particular evidentiary texture it ultimately produced. Within days of Le failing to appear for her scheduled shift, a community search effort was organized, drawing volunteers and sustained media attention across the Bay Area over the weeks that followed. Investigators simultaneously pursued the digital record. Esteban's search history, which had been preserved on her devices and recovered through forensic extraction, became one of the most extensively documented pieces of pre-crime digital evidence in the case file. The searches for Lee's home address, conducted across multiple sessions spanning months, established that Esteban had been actively attempting to locate Lee's residential information. The searches related to inducing cardiac events and breaking down locked doors, documented with their timestamps intact, gave investigators a chronological record that prosecutors would later argue reflected not curiosity, but preparation. Cellular tower records, placing Esteban's phone at the medical center during the relevant window, combined with the DNA blood evidence from the shoe and the vehicle, converged into an evidentiary picture that investigators assessed as sufficient to support charges of first-degree murder. At trial, prosecutors built their case around the digital evidence, the physical forensic findings, and the cellular location data, presenting each element as part of a coherent, documented sequence. The defense challenged the interpretation of the circumstantial evidence and the reliability of the forensic chain of custody at several points, arguing that the prosecution's account depended on inferences that had not been corroborated by direct witness testimony, placing Esteban at the specific point of contact with Gelia. The jury heard the full evidentiary record over the course of proceedings that included testimony from forensic analysts, cellular data experts, and witnesses familiar with the relationships between the individuals involved. On October 29, 2012, the jury returned a verdict of guilty on the charge of first-degree murder. Esteban was sentenced on December 10, 2012, to 25 years to life in California State Prison, a term that placed her earliest possible parole eligibility in 2036. She has remained incarcerated since that sentencing, and no successful appellate action has altered the conviction or its terms. The search history recovered from her devices, months of documented queries whose timestamps preceded the killing with a regularity that the forensic record preserved in full, had functioned as both the investigative anchor and the prosecutorial foundation of a case built almost entirely from the digital residue of a fixation that its subject had never known existed. The Esteban case documented its preparation in search queries and cellular data, a record created entirely by the perpetrator's own conduct and preserved without any deliberate investigative intervention until investigators went looking. The case that follows also produced its own documentary trail, but through an entirely different mechanism, one in which the perpetrator did not simply leave a digital record, but deliberately constructed one and aimed it at the person he intended to kill. Case 6, Daniel Krug. Digital forensics analysts working the case in Broomfield, Colorado, in the weeks following December 14, 2023, traced a series of burner phone numbers that had been used to send threatening messages to Crystal Krug back to cell tower activity that consistently overlapped in both geography and timing, with the documented location of a single personal device registered to her husband, a correlation that investigators noted as the first material indication that the source of the threats and the person who had presented himself as their target's protector were the same individual. Daniel Krug was 44 years old in December 2023 and had built a professional identity that placed him in the estimation of colleagues and professional contacts in the category of the unremarkable and the credentialed. He worked as an IT professional in the Denver metropolitan area, a role that carried institutional respectability without the kind of visibility that would have drawn outside attention to his private circumstances. He and Crystal Krug, 43, had been married and had established a shared life in Broomfield, a suburban community north of Denver. By late 2023, Crystal had initiated divorce proceedings, a decision whose documentation in the legal record established both the state of the marriage and the timeline against which investigators would later map everything that followed. What the divorce filing also established, retrospectively, was the context in which Daniel Krug had apparently determined that a conventional dissolution of the marriage was not the outcome he intended to accept. The scheme that investigators reconstructed through digital forensics in the weeks following Crystal's death was, in its operational complexity, without close parallel in the documented cases reviewed for this script. Beginning in the months prior to December 2023, Daniel Krug had created a network of burner phones and fabricated email accounts for the purpose of impersonating a man from Crystal's past, a former boyfriend from more than 2 decades earlier. Using those instruments, he conducted a sustained campaign of threatening and surveillance-mimicking communications directed at Crystal, constructing the appearance of an active and dangerous stalker operating from outside the marriage. He fabricated surveillance photographs designed to suggest that Crystal was being physically monitored. The communications escalated in their apparent menace across the months they were delivered. Crystal, who had no reason to question the external origin of what she was receiving, responded as the communications were designed to make her respond. She sought her husband's counsel and protection, and investigators later documented that Daniel Krug had positioned himself throughout the scheme as the concerned and attentive spouse, working to help manage the threat his wife believed she faced. On the evening of December 14th, 2023, Crystal Krug returned to the family home in Broomfield. Evidence established that Daniel Krug had positioned himself inside the garage prior to her arrival. As she entered, he attacked her from behind, striking her in the head with sufficient force to render her incapacitated, and then stabbed her in the chest. She died from her injuries at the scene. The staging of the attack, its location, the method, and the timing relative to the months of fabricated stalker communications led investigators, in their initial assessment of the scene, to consider whether the manufactured external threat narrative was intended to function as a prospective cover for what had been planned as the conclusion of the scheme from an early stage. The forensic work that exposed the fabricated stalker scenario proceeded on multiple tracks simultaneously. Cell tower analysis established the geographic overlap between the burner phone activity and Daniel Krug's personal device, with a consistency across dozens of documented contact events that investigators assessed as dispositive. Examination of the fabricated email accounts revealed that they had been created from a network address traceable to Daniel Krug's workplace infrastructure, a detail that the workplace's IT records were able to confirm through access logs. Investigators also recovered browser search activity conducted on the night before the killing that included queries related to rendering a person unconscious through blunt force, searches whose timestamps placed them within the 12-hour window preceding the attack. The trial that followed produced one of the more extensively documented digital evidence presentations in a Colorado murder proceeding in recent years. Prosecutors presented the cell tower correlation analysis, the workplace network connection to the fabricated email accounts, and the search history as interlocking components of a case whose central argument was that the stalking scenario had been manufactured by the defendant as a combination of psychological instrument and anticipated legal defense. Defense attorneys challenged the sufficiency of the digital evidence, arguing that the prosecution's reconstruction of the scheme required inferences that the raw data did not conclusively establish. The jury returned a verdict of guilty on all counts: first-degree murder, stalking, and criminal impersonation. In April 2025, Daniel Krug was sentenced to life in prison without the possibility of parole, with an additional consecutive term of 9.5 years applied to the stalking and criminal impersonation convictions. He is currently incarcerated in the Colorado State Prison System with no parole eligibility. The burner phone records, traced back to a single personal device through cell tower geography, had collapsed the fabricated architecture of a scheme whose operational sophistication had been designed to point investigators in every direction except the one where the answer had been standing all along. The Krug case inverted the stalking dynamic at every level: manufactured threat, controlled narrative, intimate perpetrator. The case that follows returns to something more direct: a relationship that ended, a refusal to accept that ending, and a documented trail of escalating conduct that every relevant institution had the opportunity to interrupt before a veteran was killed outside his own apartment. Case 7. Vegas Bray. 7 separate documented incidents of vandalism and harassment directed at Victor Sacado had been reported to law enforcement in Imperial Beach, California, across the 12 months preceding October 2012. A recorded sequence that investigators reviewing the case file after the events of October 16th noted had not, at any point in its accumulation, produced a legal intervention sufficient to alter the trajectory of what the record itself had been describing in incremental steps for over a year. Vegas Bray was 27 years old in the fall of 2012 and had served in the United States Navy. a background that she shared with Victor Saucedo, 31, the man she had dated before their relationship ended in 2011. Both had been stationed in the San Diego area, and the geographic proximity that military service had created between them did not dissolve when the relationship did. Bray had grown up with a social history that people who knew her described in terms that did not foreground instability. She was regarded as capable and socially functional in the context where her peers observed her, and her military service had provided a structured institutional framework that her conduct during that period had not visibly strained. What the year following the breakup revealed was a set of behaviors that bore no relationship to that prior presentation. The documented incidents that accumulated between 2011 and October 2012 were not ambiguous in their nature or their target. They were repeated, specific, and directed consistently at one person and his immediate physical environment. The documented harassment incidents that investigators assembled into the case record covered a range of conduct. Saucedo's vehicle tires were slashed on multiple occasions. Investigators attributed 7 separate documented acts of vandalism and harassment to Bray across the 12-month period. Unwanted substances were placed on his apartment door. When Saucedo relocated his residence in an attempt to create physical distance from the ongoing contact, Bray was documented as having identified his new address and resumed the same pattern of conduct at the new location, a tracking behavior that investigators assessed as reflecting active effort to re-establish proximity after the geographic barrier he had attempted to create. At no point during the documented accumulation of these incidents did the legal interventions pursued, reports filed, complaints documented, result in an outcome that materially altered Bray's access to Saucedo or the continuation of her conduct. The record existed. The pattern it described was consistent and escalating. And on the morning of October 16th, 2012, Bray appeared at Saucedo's Imperial Beach apartment. Evidence established that Bray arrived at the apartment armed with a firearm. Saucedo was shot 9 times and died from his injuries. Bray was located and taken into custody the same day. The investigation did not require an extended identification phase, given the documented history of contact between Bray and Saucedo and the witness accounts that placed her at the location. The arrest followed within hours of the killing, and the case file that investigators assembled in the days that followed drew directly from the 12 months of prior incident documentation, a pre-existing evidentiary record that required less construction than assembly, given how thoroughly the preceding conduct had been reported and filed. The trial proceeded in San Diego County Superior Court, with prosecutors building their case around the documented history and the physical evidence connecting Bray to the scene and the weapon. The prosecution's argument was straightforward in its structural logic. The 7 prior incidents of harassment and vandalism, the documented relocation tracking, and the acquisition of a firearm formed a sequence whose terminal point the evidence established with the physical and forensic record from October 16th. Defense attorneys challenged aspects of the physical evidence and the characterization of the prior incidents as constituting a coherent, premeditated plan, rather than a pattern of emotionally disordered conduct, a distinction that carried legal weight in the context of the first-degree murder charge. The jury heard the full evidentiary record and returned a verdict of guilty on first-degree murder in November 2015. At sentencing on January 8, 2016, Bray received a term of 50 years to life in California State Prison. The sentence included the mandatory minimum enhancements applicable under California law to the circumstances of the crime, and the 50-year floor on the term meant that any parole review, under the most optimistic timeline available to her, would not occur until she had served decades beyond her current age. She has remained incarcerated in the California State Correctional System since sentencing, with no successful appellate action on record as of the time this script was prepared. The 7 documented incident reports that had accumulated across 12 months, each one a recorded data point in a pattern that the file described with increasing clarity, had neither individually nor collectively produced an intervention. They had, instead, become the evidentiary foundation for a murder prosecution. The Bray case is, at its structural core, about what documented warnings look like when they are read backward from a killing rather than forward from a filing. The case that follows carried its own documentation, years of it, across multiple victims and multiple legal proceedings. And what that record ultimately describes is not a single failure, but a cascading series of them, each one compounding the next, until 8 people were dead inside a single house in Houston. Case 8, David Conley. Among the first pieces of evidence that Harris County investigators processed in the hours following the events of August 8, 2015, on Falling Oaks Road was a text message sent from inside the residence. 2 words and a name transmitted from Valerie Jackson's phone to her mother during the period in which the house was occupied. A communication whose existence confirmed that at least one person inside had been conscious, aware, and attempting to reach the outside world, while the situation it described was still in progress. David Ray Conley III was 48 years old in August 2015, and the institutional record that followed his name through the Harris County criminal justice system was neither short nor difficult to locate. He had been convicted in 2002 on a felony retaliation charge involving Valerie Jackson, a prior case in which Jackson had subsequently recanted, a development that contributed to a disposition that resulted in a 5-year sentence. The conviction and its circumstances were documented. The relationship between Conley and Jackson and the conduct it had produced over the years of their contact had generated a paper trail that crossed multiple jurisdictions and involved multiple interactions with law enforcement, protective services, and the courts. Conley had been released following the prior sentence and had, in the years between that release and August 2015, maintained a presence in the geographic and social orbit of a woman who had sought legal protection from him. Valerie Jackson was 40 years old in the summer of 2015. She was married to Dwayne Jackson Sr., 50, and the household on Falling Oaks Road included 6 children: Nathaniel Conley, 13, David Conley's biological son, and 5 of Valerie and Dwayne's children: Honesty, 11, Dwayne Jr., 10, Caleb, 9, Trinity, 7, and Jonah, 6. In the period immediately preceding August 8th, Jackson had changed the locks on the Falling Oaks Road residence. Investigators documented this as a deliberate physical boundary, a tangible action taken to restrict Conley's access to a home he had previously been able to enter. Evidence established that on the evening of August 8th, Conley breached that boundary by entering the residence. He was armed with a 9mm handgun. Investigators reconstructed the sequence of events through Conley's own subsequent statements to law enforcement, the forensic evidence recovered from the scene, and the text message Valerie Jackson had managed to send to her mother. The text read, "911 and DVD has a gun." Prosecutors established that Conley located the family members, handcuffing them across the home's 3 bedrooms, and shot all 8 individuals in the back of the head in a sequence that, according to his own later account to detectives, placed Valerie last after she had been made to witness what preceded her own killing. His account to investigators also included a statement regarding Nathaniel, his own biological son, that was documented in the case record and that the prosecution presented as evidence of the deliberate, calculated nature of the conduct across the full duration of the events that night. The law enforcement response was triggered by calls from Valerie Jackson's mother after receiving the text, as well as by neighbors who had observed activity around the residence. Harris County Sheriff's deputies established a perimeter around the Falling Oaks Road property, and Conley surrendered to officers following a standoff. He was taken into custody that evening. The forensic work conducted in the days that followed established the cause of death for each of the 8 victims, confirmed the weapon used, and corroborated the sequence Conley himself had described in his jailhouse interview with detectives. A confession whose existence simplified the evidentiary task prosecutors faced, but did not reduce the procedural complexity of a capital case involving 8 victims and a decade and a half of documented prior conduct. Investigators also pulled the full documented history of Conley's interactions with Jackson and the prior criminal proceedings: the 2002 conviction, the recantation, the subsequent release, as contextual evidence that the prosecution would incorporate into its broader case narrative. Prosecutors charged Conley with capital murder. The capital designation, carrying the possibility of the death penalty under Texas law, triggered the full procedural architecture of a capital proceeding, including an extended pretrial phase, expert evaluations, and evidentiary hearings that extended the timeline from the 2015 arrest to the 2021 trial. In the years between arrest and trial, Defense attorneys pursued a mitigation strategy that centered on Conley's intellectual capacity, presenting expert testimony and evaluation records, arguing that he met the legal standard for intellectual disability established by the United States Supreme Court in Atkins versus Virginia, a standard that, if met, barred the imposition of the death penalty regardless of the nature of the offense. The court found, following an evaluation process, that Conley did qualify under that standard. The death penalty was removed from the sentencing options available to the jury. The trial itself, which proceeded in October 2021 on the underlying capital murder charges, presented the forensic evidence, Conley's own confession, the text message sent by Valerie Jackson, and the documented prior history as the central pillars of the prosecution's case. The jury returned a verdict of guilty on October 7, 2021. Given the pretrial finding on intellectual disability and the removal of the death penalty from consideration, the sentencing outcome was life in prison without the possibility of parole, a term that was imposed and under which Conley currently remains incarcerated in the Texas Department of Criminal Justice. The text message Valerie Jackson sent to her mother, 2 fragments transmitted from inside a house where 8 people would not survive the night, had reached the outside world and initiated the response that, while it did not arrive in time to alter the outcome, produced the documentation that would carry the case through 6 years of legal proceedings to its conclusion. What the Falling Oaks case makes visible in the full scope of its documented record is the distance between what a file contains and what an institution does with its contents. The case that follows operates on an entirely different register, not a history of documented violence stretching across decades, but a relationship that existed almost entirely in a digital space between people who had never met in person, and a killing that was arranged across state lines before either principal had stood in the same room. Case 9, Denali Brehmer, Anchorage Police. Department investigators reviewing the digital communications recovered from Denali Brehmer's phone in the days following Cynthia Hoffman's disappearance in June 2019, found a documented exchange history with an online contact whose stated identity, a wealthy benefactor promising millions of dollars in exchange for specific acts, could not be verified against any real-world person at the coordinates the contact had provided, a discrepancy that prompted investigators to expand their digital trace request across state lines before the full architecture of the scheme became apparent. Denali, Dakota. Sky Brehmer was 18 years old in the spring of 2019, living what her social circle described as an ordinary student life with no institutional history that would have distinguished her from her peers in any formal record. She had grown up in Alaska and had, by the accounts of people who knew her at the time, a social personality that presented as outgoing and relational, characteristics that had produced a network of friendships and acquaintances that included Cynthia Hoffman, 19, whom Brehmer had known since childhood. Hoffman was a young woman whose life in Anchorage was documented in the ordinary texture of a 19-year-old's daily existence. She had a social network, a family who knew her routine, and no known connection to the circumstances that would end her life. What connected her to those circumstances was not her own conduct, but her proximity to Brehmer, and what had taken hold of Brehmer's conduct in the months preceding June 2019 was a relationship that existed entirely within the boundaries of a screen. The online contact, who identified himself as a millionaire named Tyler, had established a sustained digital relationship with Brehmer across a period that investigators, working through the recovered message history, were able to document as extending back sufficiently to have produced a level of psychological investment on Brehmer's part that the subsequent communications exploited with increasing specificity. Tyler had promised Brehmer financial transfers amounting to $9 million. The conditions attached to that promise, as the message history documented them, escalated from requests for photographs and personal information to explicit instructions that Brehmer kill someone and provide photographic evidence of the act as proof of completion. The message history recovered from Brehmer's phone documented her responses to those instructions, including her recruitment of a small group of acquaintances to assist in the plan. Across a thread that investigators described as among the most explicit pre-crime digital documentation of a murder-for-hire arrangement they had encountered in the Anchorage jurisdiction. On June 2, 2019, Brehmer contacted Cynthia Hoffman and arranged to meet her for what Hoffman understood to be a social outing, a hike at Thunderbird Falls near Chugiak, north of Anchorage. The group that assembled that day included Brehmer and several individuals she had recruited. Evidence established that once the group reached a sufficiently remote point along the trail, Hoffman was shot. Her body was subsequently moved and placed in a river. She was reported missing by her family when she failed to return, and investigators initiated a search that within days produced both the recovery of her remains and the digital evidence chain that connected the killing to Brehmer and her associates. Photographs that Brehmer had taken and transmitted to the Tyler contact as proof of completion were recovered from her phone and from the message thread. Documentation that served simultaneously as the evidence of the crime and the evidence of the instruction chain that had preceded it. The investigative work that followed the initial arrests focused heavily on identifying Tyler, the individual whose instructions had set the scheme in motion and whose existence, investigators established, was not confined to the Brehmer communication thread. Darren Schillmiller, an Indiana resident, was ultimately identified as the person behind the Tyler persona through a digital trace that connected his online activity to the account used in the Brehmer exchanges and to similar schemes he had conducted with other individuals across multiple platforms. Schillmiller had never met Brehmer in person. He had never been to Alaska. The entire operational relationship between them had existed within a digital channel, and the killing it produced had been carried out by someone who had never been in the same physical space as the person whose instructions she followed. Schillmiller was arrested in Indiana and faced separate federal proceedings related to his conduct. Brehmer's own legal proceedings extended across several years before reaching their conclusion. She initially entered a guilty plea and cooperated with prosecutors, a decision that factored into the sentencing calculus that the court ultimately applied. In February 2024, following a process that included multiple procedural stages and the resolution of charges against her co-participants, Brehmer was sentenced to 99 years in prison without the possibility of parole. The sentence was imposed under Alaska's applicable statutory framework and reflected both the nature of the offense and the court's assessment of the premeditation documented in the message record. She is currently incarcerated in the Alaska Correctional System. The online contact, whose promise of $9 million had initiated the chain, documented in a message thread that Brehmer had preserved on the same device investigators seized within days of the killing, had constructed a scheme whose only physical reality had been the death of a 19-year-old who had simply been asked on a hike by someone she had known since childhood. The Brehmer case located its obsession in a digital relationship with a person who did not exist as described, a fixation on an invented persona that produced a real death. The case that closes this documentary also traveled through a screen before it arrived at a doorstep, but the fixation at its center was not manufactured by a stranger across state lines. It began and ended with a dispute between two brothers, carried across a social media platform until one of them decided to resolve it in person, armed and broadcasting. Case 10, Anthony Gelia. Jackson, Michigan investigators processing the evidence gathered in the hours following the death of Brittany Southwell on November 3, 2016, did not need to reconstruct the sequence of events through forensic inference or witness canvassing. The primary evidentiary document in the case had been broadcast in real time to a live online audience, and the footage, which investigators were able to recover and preserve within hours of the incident, showed the perpetrator's face, his location, his stated purpose, and the moment he discharged the weapon that killed a 26-year-old mother holding her infant child. Anthony Gelia was 20 years old in November 2016 and lived in Jackson, Michigan, a mid-sized city in the south-central part of the state, whose post-industrial economic geography had produced the kind of community density where the social distances between people were short, and the disputes that arose within those distances were sometimes conducted with a visibility that the architecture of social media had by 2016 dramatically expanded. Gelia had no criminal history that placed him in any institutional record as a significant risk indicator before the events of that November night. He was not a figure who had attracted formal law enforcement attention through prior conduct. He had a brother. The nature of the dispute between them, conducted across Facebook in the weeks and days preceding November 3rd, was documented in the platform's own records and in the accounts of people who had observed it. It was, in the typology of online conflicts, a dispute whose specific content mattered less than the intensity with which Gelia appeared to have internalized it and the decision he reached about how it should be resolved. The Facebook Live session that Gelia initiated on the night of November 3rd, 2016, was, in the evidentiary record it created, both the instrument of the crime and the document of it. Gelia activated the live broadcast on his account and, with the camera running and an audience accumulating in real time, moved through the exterior of a residential property in Jackson while narrating his purpose, which he stated on the recording as a direct confrontation with his brother over the ongoing dispute. Evidence established that the residence he approached was not his own, and that his entry into it was not authorized. He was armed. As he moved through the property and discharged the weapon, a bullet struck Brittany Southwell, who was present in the residence and who, by witness accounts and the physical evidence recovered from the scene, had been holding her infant child at the moment she was struck. She died from her injuries. The infant was not physically harmed. The Facebook Live footage, which had been transmitted to and observed by a live audience during the incident itself, captured the entire sequence from Gelia's approach to the moment of discharge in a continuous record whose evidentiary completeness was, in the assessment of investigators who reviewed it, without precedent in their prior case experience. Investigators secured the footage within hours of the incident through coordination with Facebook's law enforcement response protocols, and the platform's own records established the account ownership, the broadcast timestamp, and the geographic metadata embedded in the session. Gelia was identified from the footage itself. His face was visible across multiple frames of the recording and was located and arrested rapidly after the incident. The investigation did not present the identification challenge that cases without such documentation typically require. The evidentiary work focused instead on establishing the legal elements of the charge, the intent, the circumstances of the entry, and the relationship between the target of the stated confrontation and the victim who was killed, in a form that the prosecution could present to a jury as a coherent legal narrative, not merely a recording of what had occurred. The prosecution presented the Facebook Live footage as its central evidentiary exhibit, supplemented by the platform records establishing account ownership and broadcast timing, the physical forensic evidence from the scene, and witness testimony regarding both the events of November 3rd and the prior online dispute that Gelia had documented as his stated motivation. Defense attorneys raised arguments related to the degree of intent applicable to the charge, the distinction between a deliberate targeting of the victim and the consequences of a confrontation directed at someone else, and challenged the sufficiency of the evidence to establish the specific mental state required for first-degree murder as opposed to a lesser charge. The jury considered those arguments in the context of the footage, the platform records, and the forensic evidence, and returned a verdict of guilty on first-degree felony murder. Gelia was sentenced in 2018 to life in prison without the possibility of parole. He is currently incarcerated in the Michigan Department of Correction system with no parole eligibility and no successful appellate action on record as of the preparation of this script. The Facebook Live recording, recovered, preserved, and presented to a jury as the primary evidence in a murder prosecution, became one of the most widely cited examples in subsequent legal and academic discussions of self-incriminating social media evidence referenced in law enforcement training materials and legal scholarship as a landmark illustration of how the platforms people use to broadcast their conduct can function as the instruments of their own accountability. Brittany Southwell, 26 years old, holding her infant child in a residence she had every reason to believe was safe on the night of November 3rd, 2016, had no documented connection to the dispute that had brought Anthony Gelia to that address. The footage that recorded what happened to her also recorded the face of the person responsible in real time with an audience watching.